we should acknowledge that it cannot be easy for you being on the witness stand for a long time. But thank you. We are making some progress, and we hope that Advocate Ngcukaitobi, we would finish with Advocate Batohi's evidence before we go on recess, hopefully without being directive. But let's see how far we go.
Thank you, Madam Chair. I get the message.
Advocate Batohi, you are still under oath.
Noted, Chairperson.
Thank you. You may proceed, Councillor.
Thank you, Madam Chair. Advocate Batohi, I want to move on to a different topic. You mentioned a few times that out of all of the cases, the one case that was prosecuted resulted in an acquittal, correct?
Yes, that's correct.
Now, that case was the case of Nkabinde, which is recorded as CAS 03/04/2010, correct?
I can't recall the CAS number.
Okay, well, I can help you. If you can go to file 3, page 74.
There's one and two. You can check on that. $374.
Page 74 at file 3. That is the statement of the mother of Nkabinde, who was killed by Warrant Officer Padiache. And there is a case number at the top.
I see that.
So do you accept that the one case that was prosecuted that resulted in an acquittal
I
is that
accept that.
case? Yes. Now, the statement of the mother starts at 74 to 79. Is that correct?
That is so.
The statement of the father.
I beg your pardon. Is the name there?
Yes, Lindy where there's
Ndlovu.
Yes.
Is that in Ndlovu?
Yes, Ndlovu.
Thank you.
Yes. Lindy where there's Ndlovu. That is the mother of Nkabinde, the 16-year-old boy. The statement of the father, Sibusiso Wiseman Ndlovu, starts at page 80. Until page 87. Is that correct?
That is so.
And a supplementary statement from the father, Wiseman Sibusiso Ndlovu, is at page 88.
That is so.
Yes. Now, I just want to understand the reason why you've singled out this case as the only case that resulted in an acquittal. Is it to say that it proves that you were right in the withdrawal of the cases, or it proves that the DPP was right in the withdrawal of the other cases?
It's just a fact.
Okay, it's a neutral fact. It doesn't prove anything.
Well, they were declined, the DPP declined and prosecuted this case, and there was a withdrawal. That's a fact.
I don't think you're answering me. I was asking for the reason why that fact was important for you to repeatedly mention. Is it because it supports your thesis that there was no evidence, or it was just a neutral fact?
It's a fact. You can make what you want of it.
And you will not answer why you thought that fact was important to be mentioned.
There's lots of facts that I've mentioned. Some are important, some less important.
I'm not asking you about other facts. I'm asking you about this particular fact. You will not answer why you thought that fact was important to mention or not.
I think it's part of what happened in this matter. It was important that I gave the complete picture.
Now, what you did not disclose in your alleged complete picture is that the mother of Mr. Ndlovu, through Miss Mary DeHaas, complained bitterly about the conduct of the prosecutor in suppressing evidence. You remember that complaint?
Mary DeHaas has written a number of letters to me. I can't recall one specifically about this matter.
I don't understand that. Ms. DeHaas was always assisting the mother of the child, Mrs. Linde Ndlovu. She wrote to you complaining bitterly about the conduct of Advocate Sankar, in which she stated that Advocate Sankar was guilty of dereliction of duty, guilty of suppression of evidence in the way that case was prosecuted. You say you don't remember that.
I'm trying to think back. I think you are right. There was a complaint about this, which I forwarded to the DPP, who inquired into the matter and found that there was no improper conduct, if I recall correctly, on his part.
Can you just explain to...
Before you do that, Counsel, who is Advocate Sankar?
Advocate Sankar was the prosecutor assigned to prosecute this case.
The Isikaweni matter.
The Esikaweni matter, which was a murder charge against Warrant Officer Padayachi.
And the answer, Advocate Batohi, is that the matter was forwarded to the DPP. Would it have been the DPP KZN, and who was that?
That's correct. It would be Advocate Elaine Zungu, sorry, now Harrison. Advocate Elaine Harrison.
I beg your pardon?
Advocate Elaine Harrison.
Elaine Harrison.
Now,
thank you.
I'm not yet there, Advocate Batohi. I am still on the question of non-disclosure. Why have you not disclosed that there was a complaint of suppression of evidence against the prosecutor who prosecuted this case?
It wasn't, I didn't mean to withhold evidence. It's just something that I didn't think about. It's not non-disclosure. I've got nothing to hide with that.
Yes. The problem with that statement is that yesterday you were going on about justice for victims. You repeatedly mentioned that the only case that was prosecuted resulted in an acquittal. Any sensible person would have thought that a complete picture would oblige you to disclose that there was a complaint of suppression of evidence against the NPA's prosecutor.
I can't recall what exactly the complaint was, but I didn't intend to withhold anything or not disclose it for any reason.
That's why I'm asking you for the reason why this was not brought to the attention of the panel. You say it was not your intention to withhold it, but as a fact, you never told the panel. If you read your statement under oath, your statement simply blithely says the one case that was prosecuted resulted in an acquittal, never actually engages with the complaint that came afterwards.
The matter was dealt with. I didn't intend to withhold it, any evidence. It just didn't occur to me at the time that it would be relevant in this context.
You say that it's because you did not think it was relevant.
In this context, yes.
Now, if you go to page 154 of file 3, that document is the complaint by Mrs. De Haas on behalf of Mrs. Ndlovu, the mother of the child.
I see that.
Document is that
Page 154, Madam Chair. 154
I beg your
of
pardon.
file
I
3.
beg your pardon.
At paragraph 2, this is what is stated. Under A of my letter of 18 November 2022, I criticize your failure to prosecute members of organized crime in what became known as the Katomano Squad for killing KwaZindlovu, a child asleep on a sofa in his own home, despite the evidence available to the prosecution. This was a particularly heinous crime, and when, after a very long struggle on my part on behalf of the heartbroken parents of the child, there was a prosecution, it was only one member, a certain warrant officer Padayache, when it should have been common purpose. Do you see that?
I do.
Padayache had for years stood accused of serious crimes in the Umbilo area, Durban, including drug running and murder. But had I known the cruelty I would subject the parents to at the hands of the prosecution, I would not have motivated for a prosecution, since I believe that justice was deliberately defeated. Now, I stated to you at the beginning that your prosecutors stood accused of defeating the ends of justice. You said you did not remember that. Do you now remember it now that I'm reading it?
I do.
Yes. Then she continues, the case should have been held in Mbangeni Regional Court, where the parents live. But they were made to travel to and from to Durban on a daily basis without the support of family and friends, because the SPP advocate, Sankar, that is where the name comes from, Madam Chair, said that he needed an experienced magistrate available to Durban to hear it. And you see that here, what she is talking about is the inconvenience placed on the poor parents of KwaZindlovu having to travel long distances without the support of the state. Correct?
I see that.
Yes. Then it continues. The magistrate who had it was acting. However, Sankar's failure to use the reports we had provided him from the 3 experts, the late Frank Dartin, top pathologist Dr. Steve Naidu, and top ballistic expert Koba Stale, I believe constitutes defeating the ends of justice. Now, I said to you that your prosecutors were accused of suppression of evidence. Remember that?
I do.
Yes. Then it continues. Hardly any witnesses were called and cross-examined. I may take my complaint about Advocate Sankar, who went out of his way to persuade the parents to settle for an inquest, despite there being all the evidence needed, which he did not use to prosecute further. Can you just explain to me, when it was stated to you that Advocate Sankar had tried to force the parents to settle for an inquest,
the DPP to look into the matter?
I'm asking about yourself. Why did you not intervene as the NDPP?
That is my intervention.
We don't even have any letters, any statements from you to the DPP in this record because of your decision not to disclose these facts.
It was not a decision not to disclose these facts.
Well, I thought you said you considered it irrelevant. I would regard that to be a decision.
It was not a decision not to disclose these facts. The matter didn't come up.
Yes. So you are saying to me, a parent of a child who has just been killed by the police writes to the NDPP and says to you, your prosecutors stand accused of defeating the ends of justice because they have suppressed evidence and they've tried to force the family to settle for an inquest. The only intervention you can make is to refer it to the DPP.
That is a very serious issue. And of course, the first step is to ask the DPP to look into the matter, which is what I did.
Is there any report from the DPP that exists in your office?
There should be.
Is there any independent investigation that was conducted in this matter?
There wasn't.
There was no independent investigation?
There was no independent investigation.
Just explain this.
And I beg your pardon. And this DPP you are referring to is the same Madam Harrison?
That is correct, Chairperson.
Why did you not call for an independent investigation? This is, your prosecutors are accused of committing crimes.
The DPP looked into the matter and sent me a report on the matter. And I can assume that because of what she said in the report, we didn't consider it necessary in the circumstances.
Well, I don't understand that. The prosecutor is accused of defeating the ends of justice. It is brought to the attention of the NDPP. The NDPP fails to conduct an independent investigation to verify what transpired and comes to an inquiry and says she's basing her answers on an assumption. Is that what you want us to believe?
No, I'm saying that I referred the matter to the DPP, who looked into the matter and provided a report on it.
No, I think we've moved past that stage. We know that you did so. I'm asking you about why, when your own prosecutors are accused of effectively throwing away a case, you don't subject that to an independent investigation.
The first step is to ask the DPP for a report. And depending on what's in that report, we consider whether further steps are necessary. In this particular case, I am assuming, because I don't have the report before me, that on the basis of that report, no further steps were considered necessary.
Well, I would imagine you would remember this because the letter is dated the 12th of December, 2024. It's a fairly recent occurrence. You would know why you elected not to conduct an independent investigation, despite the grave accusation brought to your personal attention by a grieving parent.
I can't say now.
You can't say?
No.
Then it continues. I believe that the blame for effectively defeating the ends of justice is a collective one, for which the prosecuting authority is responsible, because it had fought tooth and nail against the prosecution from the time the child was killed, with the exception of when Top Hawks members and the prosecutors from other provinces arrested those who had been killed. Having gone through the sham of a prosecution has traumatized the parents of the boy further, especially as, to rub salt into the wound, the police had claimed at the time of the killing that the child was a criminal, and their funeral policy holder refused to cover the funeral costs on the basis that the police had said he was a criminal. It is clear from character references from his teachers that he was a quiet and it is clear from character references from his teachers that he was a quiet and a well-behaved boy. So in addition to inflicting secondary victimization on the parents, they have engaged in character assassination of a child. Just tell me, do you honestly believe that the actions that you took to inquire into a travesty of justice as alleged were sufficient for you as the NDPP?
This is a matter when all of the dockets came back to me, all the murder dockets. This is the one that I questioned because I looked at the docket and the evidence in this matter, and initially there was a decision not to prosecute. And I sent it back and I said, look at this more carefully. I can't recall the detail, but I sent it back to the DPP to reconsider the matter, saying that I thought that this matter should be prosecuted. And they did reconsider the matter, and the DPP decided to prosecute in this matter.
I don't think you're answering my question. I'm talking about the complaint that came thereafter, that the prosecution was intentionally botched. I'm asking you if you honestly believe that your reaction of handing this to the DPP, not even knowing what the DPP said and why there was no independent investigation, do you honestly believe, sitting there as the NDPP, that that was sufficient?
I do honestly believe that that was sufficient in the circumstances.
Even though you don't even know why no independent investigation was held?
I can assume that it's on the basis of the DPP's report that was the case. Because if there was anything in that report to suggest otherwise, we would have had an investigation.
But you don't even tell us what that report said.
I can't because I don't have it in front of me. But I do have my letter, which is in your bundle.
I'm coming to your letter, and you are running ahead of yourself. I'm still asking you about your evidence that you gave this to the DPP. I'm asking whether you honestly believe that where your prosecutors were accused of intentionally defeating the ends of justice, that was sufficient.
I do.
Yes. Then the writer of the letter continues. I have lost count of the cases in which I have helped parents to try and get justice for children killed. But this is the worst case I have ever experienced, thanks to the National Prosecuting Authority, for which you bear responsibility. I hope that all of you who are complicit in this travesty of justice will experience at least twinges of conscience. Now, you then submitted a response, which you've been keen to move towards.
No, I just mentioned it was there.
Yes, well, that's what I am going to ask you. This document here, this letter, was submitted by us. We received it from external witnesses who watched your evidence, and they were horrified at the fact that you claimed that there was an acquittal on Mr. Ndlovu, on Nkabinde, but you never disclosed that you yourself were made aware of the suppression of evidence. That's why it's there. It's not been brought there by you. It's been brought here by Mr. Chauke because people approached him and were horrified at your evidence. Can you explain why is this letter introduced by Mr. Chauke and not by you?
I mentioned earlier, and my response remains the same. There was no intention to suppress anything.
Advocate Batohi, you must have mentioned this acquittal at least 3 times. It's in your statement. So it's something that was uppermost in your mind.
It wasn't uppermost. It was one of the facts relating to this matter. It gave the full picture. That was all.
An accusation that a prosecutor has thrown away a case will not be uppermost in your mind.
It is a very serious issue, and it will be.
This is why I am saying you had a duty to disclose it. You were intentionally withholding it from this panel.
That is not the case.
Now, we can then go through this letter, which you suppressed.
If I may just recap, what answer did you give Advocate Batohi as to why this letter was not brought to our attention by the evidence leading team?
Chairperson, I said that it's not something that I thought about. It wasn't intentional in the sense that we wanted to suppress it.
This is despite what you've just said, that it is a very serious matter?
It's a serious matter if a prosecutor is accused of attempting to defeat the ends of justice.
However, nonetheless, consider that it is not a matter that you thought was not necessary to bring forth?
I didn't, Chairperson.
Thank you.
Just one question, Advocate Batohi. If I understood this letter correctly and I was listening attentively, the reason, one of the reasons for the matter to be referred to, is it Durban? Yeah, to be referred to the place where it was to be tried, was that the magistrate that would be presiding over the matter was a magistrate with experience. Is that correct?
I see that in the letter, Chairperson.
Yes, the letter says one of the reasons was that the magistrate was an experienced magistrate. One of the reasons.
I see that in the letter, Chairperson.
And then further on, the letter says that was an acting magistrate.
I see that as well.
You see that.
Mm-hmm.
And this came to your attention when?
In December last year.
In December last year. And okay, that's fine. Thank you.
Thank you. If I can look at your letter in some detail now, you would accept that even though you will refer to the report of the DPP, that report was never finished to Mr. Haas, who was representing the family, correct?
That is correct.
Yes. Your letter also does not respond to the serious claim that the prosecutor attempted to force the parents to settle for an inquest instead of a prosecution. There's not a single line there that responds to that issue.
That is so.
Which makes me believe that the report you received that you purport to be relying on also did not deal with that issue of attempting to force victims of crime to settle for an inquest.
Possibly.
Why not? Why don't you address the allegation that there is a prosecutor who's forcing the parents of a deceased child to settle for an inquest?
I can't answer that question because if it's true, it's a very serious issue. Initially, there was a decision to hold an inquest in this matter, which was overturned.
I'm not asking you that. I'm asking you, the accusation against your prosecutor is they were forcing the parents, attempting to force, not forcing, the parents to settle for an inquest instead of a prosecution. You claim that is a serious matter. It is brought to your attention. It is not dealt with by your DPP. You also not address it. I'm asking you why.
The matter did proceed to a trial. That's the only reason I can think of in terms of why that matter was not dealt with any further, that decision was changed.
I'm asking you about the conduct of the prosecutor. Remember that you are the one who brought an issue of conduct of the prosecutor to this panel. I'm asking you, there's an egregious claim brought to your attention of an attempt to force an inquest on the parents. Why have you not made any inquiries about the conduct of the prosecutor?
I can't say anything more than I've already said on this matter.
So you don't know why?
I can only imagine it's because the matter did proceed to trial.
That is just your imagination.
Assumption.
It's just your assumption.
Mm-hmm.
Yes. Now,
the assumption that the matter was eventually tried?
No. That nothing further happened because the matter went to trial.
Okay.
Yes. Now, if you turn the page to page 160, in the third paragraph, there you say, Advocate Sankar consulted with Mr. Stale and Dr. Naidu. Now, Madam Chair, Mr. Stale was the ballistic expert.
Tell us first what this letter is. That part of 160 is part of the letter by...
This is the letter. If you turn to page 161.
Yes.
It is a letter signed by Advocate Batohi directly.
Thank you.
To the parents via Mr. Haas, explaining herself on the allegations of prosecutorial misconduct that were alleged against Advocate Sankar.
Thank you. Thank you.
Thank you. Now, one of the points you make in the third paragraph is that Advocate Sankar consulted with Mr. Stale and Dr. Naidu, and both considered during the thorough consultations that they were unable to answer the single question whether the deceased was armed with a firearm when he was shot by Warrant Officer Padayache beyond a reasonable doubt. Do you see that?
I do see that.
Can you just stick for now to the consultation with Mr. Stale and Dr. Naidu? There was another ballistic expert by Colonel Mangena in this case. Do you remember that?
I don't.
You don't? Okay, let me show it to you. If you go to file 1, Madam Chair, I'm just waiting for my junior to show me the page.
Which letter?
There is another report by a ballistic expert. Page 367. That should be file 2. Sorry, it's file 2 actually. No, because this ends at 331. Yes, it's perfect. Yeah, perfect. This is the one. Yes. Uh, 367 file 2.
Sorry, what's the number again?
367 file 2. So you will see that is an expert affidavit of Christian, I think he Captain Christian Mangena in this Escawen case 0304-2010. Correct?
That is so.
Yes. Now, the advocate who ran this case, Advocate Sankar.
Pardon, Counsel. I'm sorry to interrupt you. That seemed to be a continuation from .458. Is that document?
No, Madam Chair, are you at 367?
I'm sorry. I was looking at 467.
No, I understand.
I'm sorry.
Yes.
I'm sorry. My apology.
Yes, thank you. Now, Advocate Batohi, the advocate who was assigned to hear the matter, to prosecute the matter, Advocate Sankar, appears not to have consulted with Captain Mangena. Is that correct?
That is so.
Do you know why?
I don't.
Did you ask why?
I didn't even know that this was a witness in this matter at the time.
You didn't know that Christian Mangena was a witness in the matter?
I didn't know that there was another ballistics expert in this matter.
This is, for me, very strange. We got this ballistics report from the dockets that you sent us. How can you not know that there was this report?
At the time that I got the report from the DPP, I wouldn't have had the docket. I would have had no knowledge of what was in the docket.
Well, this was in December 2024. These dockets had been with the NDPP's office since 2019.
Counsel, are these part of those 23 or
Yes.
the dockets that you spoke about earlier?
Indeed. So this is an extract from that docket.
Yes. In fairness to Advocate Batohi, she made it clear earlier that she'd never read those dockets.
I'm making a different point. That this particular case is brought to her attention on the basis that the prosecutors have thrown the case away because they failed to call relevant ballistic reports. That is the point I'm making. She has responded in a letter in full, trying to justify the misconduct. This is the only point I'm making here. I understand the general point that she never read the dockets. Advocate Batohi, I'm sorry we have to deal with this point again. I am asking you the question
Excuse me.
around the failure to consult Captain Mangena, who was a ballistic expert. My understanding is that your answer is you don't know because you did not even know that there was another report.
I was not aware at the time that there was another ballistics expert.
Yes. Now, let's look at what he says, this ballistic expert. At page 382. These are his conclusions. After examination of the crime scene and observation of the crime scene photos and post-mortem, I am of the opinion that 12.1, the deceased here is the 16-year-old boy who was watching football. The deceased was hit by at least 3 bullets. 4 fired cartridge cases were collected from the crime scene, means 4 shots were fired and 1 bullet missed him and perforated the sofa at hole marked W2. That's the first. 12.2, the bullet that perforated the right arm of the deceased at wounds 3A and 3B also perforated the sofa at hole marked W1. 12.3, looking at the position of the deceased, I am of the opinion that wounds marked 2A and 4A were inflicted by the same bullet. And 12.4 is important. It says the bloodstain pattern on the back of the sofa next to the right arm of the deceased is classified as forward spatter. This pattern is caused as the bullet exits the target and a larger amount of high force impact spatter is directed in the same direction as the bullet. The amount of high force spatter created will depend upon the caliber of the bullet fired. The bigger the caliber, the greater the spatter. The positions of the spatter and the wound sustained indicate that the arm of the deceased during the incident was almost positioned where it is current positioned. There was a slight movement of the arm after the incident. Now, this is a case where the policeman claimed that this young man had a gun and was trying to shoot at them. The picture he's analyzing there is at 385. Can you turn to that picture? Now, he says after the analysis of the sheer velocity of the bullets, he came to the conclusion that the position of those arms was where it is at the moment, and there was only a slight movement. Can you see that?
I do.
Yes. But he says that slight movement was after the incident. Can you see that?
I see that.
Yes. Then he continues. The injuries and damages caused by all 4 bullets had characteristics of high-velocity bullets. This is most probably 5.56 millimeter caliber bullets, supported by a number of fired 5.56 times 45 millimeter caliber cartridges. Now, other reports say that those bullets are only shot by R4s and R5s. Those are machine guns. Do you know that?
No, but I accept it.
But they also say what those bullets do, the 5.56 caliber bullets, explode inside the body of the victim. Do you know that?
I'm not aware.
And that is why the experts then say, when you use this type of a bullet that is intended to turn and explode inside the body of the victim, it is only consistent with the intention to kill. Do you know that?
I'm not aware of that.
It is expressly not consistent with an intention to arrest a suspect. Do you know that?
No, I'm not.
Now, Captain Mangena continues at 12.6. Looking at the wounds sustained, the blood-stained pattern and the bullet holes, all these confirm that the deceased was shot while in a lying position on the sofa. Now, we know that lying position because we have page 385. But the expert is explicitly clear that his opinion is that this young man was shot while lying on a sofa.
Mm.
Do you have any comment on that?
I see that, and it is very concerning that this witness expert was not consulted. I agree with that, and was not called at the trial.
Advocate Batohi, it's no help for you to be concerned today when this was brought to your attention in December 2024, that here is an expert report. It is in the docket. Your prosecutors don't consult with him. He is not called as a witness. So to come after the event and to say you are concerned about it really helps no one, because the parents told you this. But then there is a further problem at 12.7. They say the current position of the deceased shows slight upward movement of the left arm, and the position of the firearm is unexplainable. But we can go back to page 385. This is why it was concluded that that firearm was most probably planted by the killers of this young man.
What does that mean? That it was planted?
That it was put after they shot him. I know planting is a slang. But that firearm was put there after they shot this young man.
Any comment?
Chairperson, all I can say is that, I must accept this expert's evidence, and it is very concerning that this particular expert would not have been led at the trial.
Well, sorry, Advocate Batohi, it's not about not leading him at the trial. They did not even consult with him.
That is correct.
To understand that there are weaknesses in his evidence, etc.
That is correct.
But
and that is also very concerning.
But the report is in the docket.
As I mentioned, I was not aware of that.
And this is why your conclusion that focuses on the opinions of Mr. Stale and Dr. Naidu completely misses the point.
I agree with you now that I'm aware that there was another ballistics expert.
And this is why, if you look at 1, 2, 3, 4, 5, on the 5th paragraph, where you talk about...
Sorry, what page are you at again?
Page 160 of your letter. The 5th paragraph.
Yeah, got it.
When you are telling the parents that these experts were expressing an opinion based on the position of the firearm in the photographs, that is just wrong. because the conclusions are not based on the positioning of the firearm. We've just looked at all of the 7 conclusions. The firearm is only mentioned, the position is mentioned once at 12.7, page 382, as unexplainable. The rest of the opinions of Captain Mangen are based on a detailed analysis of the crime scene.
I see that, and I agree with you.
Now,
The specific paragraphs on page 160 would have been what you referred us earlier to, the 3rd paragraph and the 4th paragraph, I suppose.
1, 2, 3, 4. The 5th paragraph, Madam Chair, that's the one I was talking
The
about.
suspicion.
Yes, yes.
The suspicion.
The real point here is that Advocate Batohi concluded that the reason those witnesses were irrelevant is because their opinion was based on the positioning of the firearm. But that is just wrong. When you actually read the opinion of Captain Mangen, the firearm positioning is mentioned only once. The opinion is based on an analysis of the crime scene as a whole. Advocate Batohi, you can respond to that comment?
Yes, all I can say at this point is that it is extremely concerning that this, because as I said, this was a matter that I referred back to the DPP because I thought that it was a matter that needed to be prosecuted. The DPP reconsidered the matter, prosecuted the matter, but it is now concerning to know that there was another ballistics report and that this expert was not called. And I certainly won't leave it at that. It's after the fact, but it's something that I will need to look into.
Now, there is a further problem with your letter, which says that the reason Mr. Stale and Dr. Naidu were not called really revolves around the positioning of the firearm, which is what we have looked at, the 5th paragraph of page 160. It makes me believe that you did not read even the opinion of Mr. Stale and Dr. Naidu. Did you read it?
I didn't read anything. I said I didn't read the dockets.
No, I'm asking about the specific...
I did not.
Because we asked for this opinion. Madam Chair, it is at file 3, page 90. Page 90, file 3. Now, my concern here is that in the 5th paragraph, that these witnesses couldn't give evidence beyond a reasonable doubt about the positioning of the firearm as the only basis to draw from those reports shows to me it can only have been made by a person who did not read the actual report of Mr. Stale and Dr. Naidu. That's why I want to go through this report with you. If we start at page 91, under E, main factual findings. Sorry, I'll go to that. I just forgot there was a question I had to ask before this. Advocate Batohi, you know, this report that we are dealing with was not in the docket. Did you know that?
No, I'm not aware of that.
Yes. We received this again from third parties who were horrified at the evidence you were giving when they were watching it on television. Why would a report like this not be in the docket?
It should be in the docket.
But
I can't answer that. It should be in the docket. Unless there's been some reason to suppress evidence, it should be in the docket.
well, this is the whole point that was made, that this case has been intentionally botched. You are talking about this report because we assume when you say Mr. Stale and Dr. Naidu, the only joint report that we could find is this one, but it was not in the docket that you disclosed. We found it from third parties. Now, what they say here at the main factual findings under E1-2, Kwazi was 16 years old and in grade 10 at school. When the father retired to bed between 10:30 and 11 p.m., Kwazi was still watching soccer on television. The yard outside had three vehicles, a white Mercedes-Benz used by Mrs. Ndlovu, a red BMW used by Mr. Ndlovu, and a third vehicle, Baki, belonging to a friend of the family. Whilst both parents were fast asleep, there was a violent and a sudden loud sound early in the morning as the kitchen door was broken in and footsteps were heard of persons entering the kitchen before the parents could get out of their bedroom. And then several gunshots were heard, causing the parents to scramble from the bed to the floor with their younger son, Sazi. Their bedroom door was shortly thereafter opened and the husband made to lie prone, face down, in the passage outside of the bedroom 1 and lounge. Men were shortly thronging the house. If you turn over to page 92, the interval between the storming of the door and the gunshots were approximately several seconds from the parents' recall. The parents were both fast asleep at this time, and they related that they think in retrospect that Kwazi had either fallen asleep upon the couch in the lounge that night, but at that moment, when abruptly awoken, were under the impression that Kwazi was asleep in his own room. What I want to put to you about this is a factual narrative conveyed to these experts by the parents, but it is perfectly compatible with the expert opinion of Captain Mangen, who says, upon his examination of the scene, this child was shot while asleep.
I agree with you.
Yes. If you then skip E5 to E7, you go to E18. These have now killed the child. Mr. Padayache has killed the child. Then this is what happens. Mrs. Ndlovu did not know or suspect
Are
that
you reading that?
E1.8.
E1.8.
Yes, Madam Chair. Mrs. Ndlovu did
Where
not.
does it say Mr. Padayache has killed the child? Are you putting it to the witness?
Yes. When they talk about the shooting, it has already happened by this time because the shooting is at E1.3. Yes. So the child has now been killed, but this is now the aftermath. E1.8, Mrs. Ndlovu did not know or suspect Kwazi was injured and repeatedly requested for her to remove Kwazi from the room or the house, and so that she could remove both sons to their grandmother's care after the incident of the entry of the police. She was repeatedly told that they were still questioning Kwazi. It was only when her husband returned from H2 section with the police that he told her what he now suspected and was the reason for a crime scene police cordon tape applied around the scene. Mrs. Ndlovu then stormed through the tape cordon and peered into the lounge window, where she saw her son with an injury to the arm and a firearm at his side. She shortly thereafter entered with the paramedics who arrived and also managed to obtain some pictures on her cell phone. The reason why this is important is that Captain Mangena says his examination is that the crime scene must have been tampered with because there is the inexplicability of the firearm. When Mrs. Ndlovu was denied entry to the room where the child was killed, that too is compatible with an attempt to tamper with the crime scene. Otherwise, why would you stop a parent from entering the room where the child has been killed?
That's possible, I agree.
Now, if we then look at what they say, are their conclusions at page 102. Sorry, not 102. I think let's start at 101. We're going to still go to 102. 101. At E8.3. They say the 4 rifle cartridge cases indicate that at least 4 rifle shots were fired. If so, then 1 shot of these did not impact on the deceased. Now that again is consistent with Captain Mangena's conclusion that 1 of the bullets shot through the sofa and 3 landed on the body of the child. Correct?
That is correct.
Yes. Where this additional shot had impacted is not apparent in the photographs. The padded couch will not easily reveal such perforations in a photograph, but its actual examination showed a single direct impact of its 2 perforations. That again is, Captain Mangena came to the same conclusion. Then they say it is evident from the photographs that the body position had been altered at least slightly after death. Remember that this is also the same conclusion of Captain Mangena, that they tampered with the body after the death. Correct?
Yes, that's correct.
Yes. However, the location of the wounds on the body, the lack of other blood stains anywhere else in the visible surroundings other than that noted in C above, and the location of the cartridge cases on the floor all suggest that the deceased was lying in that general supine position upon the couch, as shown on the photographs when he was shot. Again, Captain Ngena also came to the same conclusion that this child was shot while in a sleeping position. Correct?
That is correct.
Yes. Then in paragraph 3, considering the incapacitating effect of the gunshots, it would also be most likely that the deceased did not also make any significant voluntary movement after the injuries. Such gunshots are very destructive and must be considered immediately incapacitating for most of these cases, not allowing for the victim to be capable of any reactive or retaliative actions. The death would also have occurred very shortly, within a few seconds, if not immediately, after the gunshots, when considering the effect of such high-velocity gunshots to the head with a lodged bullet. Now, you remember that I said to you, what the experts say is that these 5.56 millimeter bullets shot through an R4 and an R5 are weapons of killing. And that is perfectly consistent with the conclusion reached by the expert that these are very destructive and immediately incapacitating. Do you accept that?
I don't doubt that.
And then paragraph 4, the temporal sequence of body shots, which shot was sustained first, second, and third, cannot be determined from the photographs or autopsy findings. So there is no finding there. Then paragraph 5 is also a very concerning paragraph. It says, the general appearance of the posture of the deceased is that of relaxation in the supine position. This is not reconcilable with the usual posture adopted in firing a weapon. You remember that Warrant Officer Padayache claimed in his statement that this young boy had a gun and was trying to shoot at him, and he shot him 4 times in self-defense. But the experts say that narrative is inconsistent with the posture of the deceased, which was of a relaxation in a supine position, not reconcilable with the posture adopted in firing a weapon. Do you accept
I see that? Yes.
Yes. Number 6, the absence of any handgun cartridges at the scene suggests that the handgun was not fired. So even though if you go to page 385, yes. Even though if you go to page 385, there is a gun. Volume 2, Madam Chair, thank you. So even though if you go to page 385, you see under the left elbow of this young man, there is a weapon. The experts say he was supine when he was shot. No cartridges could be found, meaning that that handgun was not fired.
That's correct.
Yes. Then paragraph 7, which is also compatible with Captain Mangena. The position of the handgun on the couch is also not easily reconcilable with the final rest of the weapon if it had been held in the right hand at the time of sustaining a high-velocity destructive shot through that right forearm. If the weapon was held in the left hand, it would have landed on the body of the deceased or close to his upper thigh region. The possibility that this was not the actual position of the weapon, as depicted in the LCRC photographs at death, must be considered. They are not as forthright as Captain Mangena, but the general thrust is the same, that it is improbable, let me not say impossible, for this weapon to have been held by this young man at the time of the shooting. Do you have any comment?
I agree with that.
Yes. Now, then I wanted to then go to 102, and then if you turn to 103, there is 2 more conclusions there.
Just finished 102 at 7.
It's 102 at 7. I want to turn to 103 at 6.
At 6.
Yes.
Yes.
Yes. There are, sorry, I said 3 conclusions that are crucial to put to you. The one is at 6, where they say the evidence suggests that the deceased was in a reclining position at the time of the injuries. So they've used supine, they're now using reclining, but it all comes to the same thing. The general position and posture of the deceased suggests that he may not have had advance warning of the shots. The appearance of the blood staining indicates that the deceased was lying as depicted in the photographs at the time of the shooting, that he was likely in a relaxed position upon the couch when he sustained the injuries. So that's consistent with what we've read so far, correct?
That is correct.
Yes. Then, if you look at paragraph 8, assuming that the deceased was right-handed, the observation above may also not be reconcilable with the deceased having held a gun in his right hand at the time of sustaining the gunshots. And the reason why they mention this is because they are reading these statements of Warrant Officer Padayache that say this young man was carrying a gun on his right hand, and they're saying this is just irreconcilable with the facts. Correct?
I agree.
Then paragraph 9, the handgun seen in photographs does not appear to be cocked, and no spent handgun cartridges were found, should be spent handgun cartridges were found at the scene. So they make a different point here. is that not only was the gun not shot, it was not even cocked. Correct?
That is correct.
Yes. And then the handgun was not fired, so we've already dealt with that in the previous section. But they make a further opinion. It is also our opinion that the handgun positioning, as seen in the photographs, requires investigation, as there is a possibility that this could have been an altered scene. Now, this comes into that whole thing that this gun was most probably put there after the shooting, which is the conclusion of Captain Mangena. Do you see that?
Yes, I do.
Yes. Now, thank you. Now, the reason I've had to go through this is because in your report, or your response rather, to the family, you give a thoroughly misleading account of what the expert says, and you don't even submit to them the expert report. Was that because of what the DPP told you?
It's not misleading on my part. It was what I assume I would have received from the DPP. The way the process works in the office is that when there are these issues, it goes through the division called NPS in my office, where the DPPs report to the Deputy National. They would send reports to the NPS. They look at the reports, they draft a response for me, and then the file comes through to me, and I then look at the file and decide whether the draft needs any changes, etc., and then I send it. But that's the process. So in this case, I can only say that this was because of what the DPP sent to me, but I have to add that it is, I agree, very, very concerning that these witnesses were not called, given what we have just read now in these reports.
No, you see, Advocate Batohi, the issue of the witnesses not being called is one issue. What I am probing now is you, in a letter that you've signed, giving a misleading picture of the evidence of the ballistics.
It was what I would have written on the basis of what the DPP provided. And you may rest assured that this is something I have to follow up on.
No, this is the problem I have, is that you've repeatedly in the course of this testimony singled out this case as the one example that was prosecuted leading to an acquittal, which is why we've had to go through a thorough examination of what happened. You did not even ensure that this report we've been dealing with is part of the docket. But
I was not even aware of it, and I didn't disclose the docket. So I was not involved in that process at all. So to attribute that to me is, I think, really unfair.
No, but you refer to their report in your letter. I'm not attributing it to you. You are attributing it to yourself.
Can you refer me? Sorry, which page is that again?
Page 160 of
pages.
file 3.
File 160. Yes.
That paragraph, the third paragraph, where you are talking about the consultation of Advocate Sankar with Mr. Stale and Dr. Naidu.
I see that.
Yes. Now, this is why we've had to find their report in order to understand what did they conclude in their report, to see whether the conclusions you made were fair conclusions or unfair conclusions. We came to the conclusions that not only were they unfair, they were also misleading.
These conclusions were, I can only assume, I don't have the report now, but that is the way the process works, is the DPP would have provided a report, and this would have been drafted on the basis of that report. But I have to emphasize, on the basis of what has emerged today, I will have to look into this matter further. There seems to be something that was not right.
Yes. Now, this is part and parcel of the problem. You know, you've brought in a senior Director of Public Prosecutions of extensive experience, who went through these dockets, came to the conclusion that at least in the KwaZulu case, there should have been a prosecution. Having gone through these dockets, and you've said there was no evidence, there was no evidence, there was no evidence. You've singled this one out. You've said they were withdrawn. We tried to prosecute. There was an acquittal. We go through this on a cursory basis. The three most important witnesses, Mr. Stale, Dr. Naidu, Captain Mangena, are not called. The parents come to you and they say evidence has been suppressed. No independent investigation. I think that on that summary, it is fair to conclude that you have been complicit in denying the parents of KwaZulu justice.
If I may comment on that,
Yes.
That is certainly not a conclusion that is justified in these circumstances. As I explained, firstly, to deal with the issue of no evidence that I have mentioned, I thought I made it quite clear that it was no evidence relating to the racketeering charges. And that is why all of the dockets were sent to the DPP to look into each one of them, to see if there was evidence to charge in respect of each of the dockets. This particular case, I was not aware of these reports of the ballistics experts. Having been made aware of them today, I will certainly take steps to look into this matter, because it's on the basis of what has been read out now, it appears that these witnesses should have been called for the trial, at the trial.
No, you see, that problem, Advocate Batohi, it doesn't help for you to talk about racketeering, because this was one of the predicate offenses. So it was part of racketeering.
It does help to talk about racketeering, because racketeering has very specific elements that you need evidence to prove. And the conclusion that they came to is that there was no evidence to support the elements of the racketeering charges. And that is why I again emphasize the dockets were sent back for the DPP to consider each one of them, to decide whether charges should be brought in respect of any charges in those dockets.
No, I think we are not talking about the same thing. I am simply putting to you that this is one of the predicate offenses in the racketeering charge. Is that correct or not?
This would have been one of the predicate offenses in the racketeering charges, but you need two predicate offenses to satisfy that element for racketeering.
No, don't worry. We will go through all of them. But I'm simply putting to you that this would have been necessary for the racketeering charge because it is one of the predicate offenses.
It would have been one of the predicate offenses. That's correct.
Yes. Now, you now say, well, I'm going to investigate this matter further and I will be taking action because I can see that witnesses that should have been called were not called. The problem with all of that, it seems to me to be regret after the event that you failed to do your job diligently at the time.
That is not correct. I relied on a DPP's report. I was not aware of these documents and reports. Now that I am aware of it, I'm not going to ignore it.
Yes. Madam Chair, I'm going to move to another topic. I see that it's 10 to 11. It might be a convenient time.
If I may, this report of the DPP, Madam Harrison, I suppose.
That is correct, Chairperson.
Can it still be found?
It should be on the file, Chairperson.
Which file?
On the file in the office. Sorry, in the office file.
Is it possible that it can be made available to us?
Yes, Chairperson, can be.
When?
On Monday.
On Monday, the 15th, please assist the NPA team. Please assist in that document being filed of record so that all the parties, including ourselves, the panel, should have a look at it. We should have it by Monday. Remember, we are online, so the document can be made available to us even tomorrow. Thank you.
May I? Advocate Batohi, it is on record. It is on record that you have not read the docket relating to the racketeering charges.
That is correct, Chairperson.
And what I would like to know is your approach towards dockets in particular. Is it your approach that you have insulated yourself from reading dockets as a general approach, or what is the position?
Chairperson, as a general approach, I do not read the dockets. I get reports and evidence is summarized depending on the circumstances that led to the matter being brought to my attention. If there's something in it that sometimes I do statements, I ask for statements, but as a general rule, I rely on reports from the DPPs.
So it will be safe to say you have insulated yourself from reading the case document?
I wouldn't say I've insulated myself. It's just that it's very difficult for a DPP, for a national director to be reading dockets. So it's reasonable to expect that you would rely on reports from the prosecutors in the matter or the DPP.
Thank you.
Thank you, Council Advocate Batohi. Will take a tea adjournment until 11:15. We adjourn.